Good morning. I am Dr. Harpreet Kaur, Professor of Law at National Law University, Delhi. Today I will be dealing with the module on insider trading offence and prohibition of fraudulent and unfair trading regulations in the securities market and their implications. We know that recently we have seen that the offence of insider trading is increasing tremendously as the growth of the securities market is also going on very fast pace for the last 1 decade. SEBI had formulated 1992 regulations which prohibit the offence of insider trading. So in this module, we will deal with the insider trading regulations as well as regulations which are prohibiting fraudulent and unfair trade practices in the securities market, which are regulations of 2003, as well as the special provision of section 195 of the Companies Act 2013. Now we know that 1992 regulations are in place since 1992 only, but there has been increase in the number of offences of insider trading. So it was thought by SEBI that there should be some amendment made in the insider trading regulations. For this purpose, a committee was constituted by SEBI under the chairmanship of N.K. Sodhi, and which had given its recommendations. And while I was writing this module, the recommendations of N.K. Sodhi committee and certain other changes were proposed, and on the basis of this we had replaced the 1992 regulations with the 2015 regulations. So in this module I will be making a comparison between the 1992 regulations and 2015 regulations, and will try to make you understand that what has been the need for making such replacement and whether it will be the new regulations will be able to regulate the offence of insider trading more vigorously or not. So this is the introduction about the module. Now let us understand what is the learning objective of this module. So there are 4 learning objectives. First, we need to understand what is the insider trading and who are potential offenders for insider trading. We need to understand how insider trading is regulated in India, and also we need to understand why there was a need for the replacement of the insider trading 1992 regulations with 2015 regulations, and also we will see what are fraudulent and unfair trade practices in the securities market in India and how they are regulated. So let us first of all understand what is the prohibition contained in these 2 regulations 1992 and 2015 about the insider trading. So 1992 regulations under regulation 3 says that the insider trading is prohibited, and it says that no insider shall deal in listed securities of any company when he is in possession of any unpublished price sensitive information either on his own behalf or on behalf of any other person. So this is about the prohibition on dealing in securities when the person is having possession of unpublished price sensitive information. The second part of the prohibition says that such person should not communicate, counsel or procure any such information, whether directly or indirectly, to any person while in possession of such information that other person cannot also deal in the securities. So it is not only the prohibition in dealing by one person or any dealing on his own behalf, but the communication of this information to some other person who is also prohibited from dealing in the when he is having possession of unpublished price sensitive information. Now this prohibition is not applicable when the communication is required in the case of ordinary course of business of the company or profession or employment or under any law. Now let us look at prohibition under 2015 regulations. It says that communication or procurement of unpublished price sensitive information is prohibited, and it says that no insider shall communicate, provide or allow access to any unpublished price sensitive information to any person including other insiders of the company, and no person shall procure from any insider any unpublished price sensitive information or cause the communication by any insider of any unpublished price sensitive information which is related to a company or related to the securities which are listed or proposed to be listed. Now the exception says that such procurement or communication is allowed when it is in furtherance of legitimate purposes, performance of duties and discharge of legal obligations. So we say that the prohibition, the scope of this prohibition has been increased, and the exception which is given in 1992 regulations about the ordinary course of business, profession or employment or under in any law has been changed now with the legitimate purposes, performance of duties or discharge of legal obligations. Now, who is an insider? So, under 1992 regulations, insider is any person who is reasonably expected to have access to unpublished price sensitive information regarding the securities of a company, because he is or he was connected with the company, or he may also be deemed to have been connected with the company. So, we are talking about a person who is insider and who is also deemed to be connected with the person, or who has received or has access to such unpublished price information. So, this is the definition of insider under 1992 regulations. Let us now look at the definition under 2015 regulations. Under 2015 regulations, insider means any person who is a connected person or who is in possession of or having access to unpublished price sensitive information. So, you see that the definition has been simplified, but the scope has been widened in this definition. Let us now look at who are connected persons under 1992 regulations. So, connected person means, or it meant under 1990 regulations, as a director or of a company, or a person who is deemed to be a director of that company, or who occupies the position as an officer or employee of the company, or holds a position involving a professional or business relationship between himself or and that of the company, or who may reasonably be expected to have an access to unpublished price sensitive information. Now, over here the connected person meant that this person will be in connection with the company in only for 6 months prior to an act of insider trading. So, the person will be connected person only if he was in the category of connected persons 6 months prior to the dealing of the insider trading. Now, under 2015 regulations, the connected person means any person during the 6 months prior to the concerned act, if he has a relationship or he is connected with the company, has been associated with the company either directly or indirectly in any capacity, which may include his frequent communication with the officers of the company, any contractual or fiduciary or employment relationship with the company, or he being a director, officer or employee of the company. Now, the second part of the connected person definition says that he may be a connected person if he holds any position including a professional or business relationship between himself and the company, whether it is temporary or permanent, and that allows such person directly or indirectly access to unpublished price sensitive information, or he is reasonably expected to have such access to unpublished price sensitive information. So, again we see that the scope of the definition of connected person has been enlarged over here. Now, there is another category of deemed connected person under the 2015 regulations. Now, over here the following persons will be deemed connected persons. First, an immediate relative of the connected person, as we have discussed just now. Then any holding company or associate company or subsidiary company, any official of a stock exchange or a clearing house or a corporation, any intermediary as is specified in section 12 of the SEBI Act, as well as any investment company, trustee company, asset management company, or any employee or director of such companies. The next category of deemed persons include a banker of the company, a member of the board of trustees of a mutual fund, a member of the board of directors or an employee of a public financial institution, and any official or employee of a self-regulatory organization which is recognized by SEBI board, and a concern or firm, trust or Hindu undivided family, company or association of persons wherein a director of a company or his immediate relative or banker of the company has more than 10% of the holding or the interest in another company. So, these are the categories of deemed connected persons.